यस बोलिए।
कोई एमपी एमएलए कोर्ट से संबंधित है, आपने सेंशन के लिए उधर ऑर्डर दिया था।
क्या है, क्या हुआ
सेंशन
है?
के लिए जी 126(3) में ऑर्डर जो पास हुआ था 916 आप ही के यहाँ था, फिर 454
विटनेस प्रोटेक्शन स्कीम में ऑर्डर हुआ
नहीं हुजूर, एफआईआर लॉजिंग के लिए
हमने ऑर्डर दिया था।
लोअर कोर्ट से ऑर्डर हुआ था, हम आए थे रिट 916 2017, फिर 454 2021 में 18 में, तो फिर आपने सेंशन के लिए लिखा था, तो फिर हमने सेंशन के लिए दिया, सेंशन एब्सेंट हो गया।
और कहाँ है ऑर्डर, कहाँ है? बोलिए।
My lord, this case is related to the maintenance, my lord. I have filed revision petition, my lord. The lady having son, my lord, she was not given any maintenance, my lord, and her husband is in government service, my lord. My petition was rejected there.
प्रायोरिटी में लगा दो।
इसमें जो क्रिमिनल रीट है, इसमें एक यूडी केस जो रजिस्टर्ड हुआ है 2020 में। पिटिशनर के हस्बैंड का जो डेथ हो गया था, उनका डेड बॉडी पाया गया, और अभी तक फाइनल फॉर्म, केस डायरी, पोस्टमार्टम कुछ भी जो सबमिट नहीं हुआ है। और ये सर्टिफाइड कॉपी फाइनल फॉर्म का जब तक
कब का मैटर है ये?
जो 2020 का मैटर है, और अभी तक फाइनल फॉर्म सबमिट नहीं हुआ।
तो आपने वहाँ क्यों नहीं अप्लाई किया? इन द कोर्ट बिलो यू शुड हैव फाइल्ड एन एप्लीकेशन फॉर द लंडन मैजिस्ट्रेट।
वहाँ जो कंप्लेंट जो अथॉरिटी है वहाँ हम लोग किए थे, वहाँ के बाद जो एक यूडी केस जो है दूसरा हमारा नहीं बल्कि दूसरे यूडी केस को सबमिट किया गया है।
नहीं, व्हाट आई एम सेइंग इज दैट ओनली फॉर a direction to submit the police report. Why are you required to come here? Why don't you apply for that remedy before the learned magistrate itself?
यहाँ केवल जो शिकायत का जो कोर्ट था, जो वहाँ हम कंप्लेंट फाइल किए थे।
किया था आपने?
जी हाँ।
You had filed a complaint before the learned magistrate.
जो
That police final report is not being submitted, so please request the or direct the concerned officer to file the police report.
शिकायतकर्ता का जो कोर्ट है जो वहाँ हम किए थे।
In fact, क्या हो रहा है ना, it's a court is being overburdened by all these kind of petty kind of applications, which may be taken up in the court below itself. So anyway, दीजिए, आप देखते हैं। Yes.
लॉर्डशिप जुवेनाइल मैटर है, प्रोबेशन सुन लिया जाता है।
जुवेनाइल मैटर्स दे दीजिए। बोलिए।
एनेक्सर 2 और 3 कंसर्निंग है,
देखें क्या है आपको।
एनेक्सर 1 और 2।
So I have, this court has not issued any direction. You said कि आपने डायरेक्शन दिया था सैंक्शन वाला।
जी हुजूर, तो हमने सैंक्शन के लिए लिखा था।
No, I have not issued any direction. Where is my direction?
आगे पढ़िए ना हुजूर, 22 से पारा 22।
ऐसा है, आप पढ़ दीजिए मुझे, अगर हम नहीं पढ़ पा रहे हैं।
ऐसी बात नहीं है हुजूर।
लास्ट पढ़िए जरा से, क्या ऑपरेटिव पार्ट है, पढ़िए ऑपरेटिव पार्ट पढ़िए। Read the direction part, not the discussions. Read the direction part. Ultimately, what the court has held after all discussions.
22 नंबर पारा में हुजूर कि इन दिस केस ऑफ माता जगह स्पेसिफिक क्वेश्चंस विद हैड कंसीडरेशंस बिफोर ऑनरेबल एपेक्स कोर्ट वाज द वेदर द नीड फॉर सैंक्शन टू बी कंसीडर्ड एज सून एज कंप्लेंट इन लॉस्ट एंड ऑन द एलिगेशंस देयर ऑन कंटेंट क्वेश्चन मार्क इन ऑर्डर द फुल्ली अंडरस्टैंड द view of expressed by the Honorable Apex Court, the court would reproduce paragraph 18, 19, 20 set judgment as under. ठीक है हुजूर। और लास्ट में क्योंकि हुजूर वो पेंडिंग था, वहाँ सेशन पेंडिंग था, और वहाँ से कंसिडरेशंस के लिए जो 18/10/2018 को ऑर्डर हुआ था कि नहीं आपको जो है सो सेंक्शन लाना ही लाना है, और उसमें जो यहाँ से ऑर्डर गया था 916 का सेशन पेंडिंग में, तो वो एसएचओ जो
आप
रिटर्न
क्लब कर दे रहे हैं. You are clubbing too many cases. Please read the operative part of this order. You are still not reading the operative part.
इसमें मतलब जो था वो दोस्तों आप ही का.
Why don't you read that operative part? Court is asking you to read in your
ऑपरेटिंग पार्ट हो जो
last पढ़िए ना. लास्ट में क्या कंक्लूजन आया कोर्ट का?
The judgment of Hon'ble Court in the case of Binnu Bhai Hari Bhai Supra of the petitioner, अच्छा, keeping the mind the provision of 197 CRPC and aforementioned judgment of the Hon'ble Apex Court, the court is a considered opinion. The impugned order is contained in an except P 23 does not suffer of any legal infirmity. The petitioner.
So you are seeking prosecution of a public officer in this case.
नहीं हो जो.
Then
The seeking of the Honorable Chief Minister with public servant.
so that writ application was dismissed by this court. You went to the Honorable Supreme Court.
Honorable Supreme Court is saying that not the in the session pending, I will not interfere this case.
So the Honorable Supreme Court did not interfere with the judgment of this court.
हाँ.
Then matter ends there. How can you make a statement in this court that this court had issued direction for sanction and then now what are you looking for?
हुजूर हमने सैंक्शन के लिए लिखा है, ठीक है, उसका सेकंड पार्ट में हम जाते हैं.
Mr. Jaiswal, please take it from me. In this case also, I think 2-3 matters I have heard. Please come with some good case. Please come with some good case. The court will definitely consider your grievance, but not the kind of cases with which you are coming. न्यूज़पेपर रिपोर्ट बनाना हो आपको, नाम छपवाना हो अखबार में तो ठीक है, आप करते रहिए वो सब. लेकिन इस तरह से अगर आप कोर्ट को इंडल्ज करेंगे, देन आई डोंट नो, द कोर्ट विल हैव टू टेक अ डिफरेंट व्यू. अब आप क्या चाह रहे हैं इस कोर्ट से बताइए?
हुजूर हम इस कोर्ट से चाह रहे हैं कि जो सीजीएम के यहाँ पेंडिंग है, हमने सीजीएम के यहाँ दिया था कि ठीक है सैंक्शन अब्सेंट है, आपके यहाँ पेंडिंग है, ठीक है, आप इसको कंसीडर कीजिए. तो सीजीएम को ऑरली कहना था कि नहीं, आप हाईकोर्ट गए हुए थे 454 में, आप हाईकोर्ट को डायरेक्शन करेगा तो ही हम आगे बढ़ेंगे, नहीं तो नहीं बढ़ेंगे.
तो हाईकोर्ट ने तो डायरेक्शन नहीं दिया ना. हाईकोर्ट ने तो डायरेक्शन नहीं दिया, हाईकोर्ट ने डिसमिस कर दिया आपका रिट एप्लीकेशन. यू वेंट टू द ऑनरेबल सुप्रीम कोर्ट.
नहीं हुजूर, इसमें हुजूर जो ऑपरेटिंग पार्ट है, जो मेन पार्ट है, उसको तो आपने डिसमिस हुजूर नहीं किया था.
क्या लिखा
है में?
क्या लिखा है पढ़िए.
ठीक है,
क्या लिखा है पढ़िए.
The writ application has been preferred invoking the extraordinary jurisdiction of the counter court under Article 226 and 227 the Constitution of India with the following prayers. ठीक है, और प्रेयर्स जो था मेरा हुजूर इंटर आलिया में, वो ऑपरेटिंग पार्ट था उस समय. और उसके बाद हुजूर क्योंकि सैंक्शन का एक प्रॉब्लम था, तो आपने सैंक्शन के लिए इसे मेंशन किया.
आप समझते हैं कि रिट कोर्ट जो है वो डायरेक्शन देगा कि आप सैंक्शन ग्रांट कर दीजिए?
सैंक्शन ग्रांट के लिए नहीं हुजूर.
हाँ.
कि आप सैंक्शन के लिए लिखे थे कि आपका सैंक्शन जो है माता जोग दोबे वाले में जो है, ठीक है, आप सैंक्शन आप मांग सकते हैं आप, क्योंकि जो लोअर कोर्ट का जो ऑर्डर था, जो एसएचओ से रिटर्न कर दिया था, ठीक है, तो उसी के अगेंस्ट में हम आए थे. हम ये रिटर्न नहीं कर सकता है ये, लेकिन आपने मान लिया उसको कि ठीक है आप सैंक्शन के लिए.
अब अगर आप बोलेंगे तो कंटेम्प्ट हो जाएगा आप पर. कंटेम्प्ट हो जाएगा इसलिए कि यू कैन नॉट आर्गू इन दिस कोर्ट अगेंस्ट द ऑर्डर ऑफ दिस कोर्ट ओनली, एंड दैट टू एन ऑर्डर विच हैज ऑलरेडी फेस्ड अ चैलेंज बिफोर द ऑनरेबल एपेक्स कोर्ट. प्लीज ट्राई टू अंडरस्टैंड. आपने तो वकालत पढ़ा है ना?
नहीं वो समझ रहे हैं बात.
तो आप फिर कैसे, हाउ कैन यू स्पीक लाइक दिस? आपने ये कर दिया, हमने क्या कर दिया? This court has passed an order after hearing you. That order was taken to a challenge before the Honorable Supreme Court, and that order has sustained the challenge. How can you make any comment against that order?
Others for the listener, Sri Hemant Kumar Karan.
On last occasion, there are certain Lordship, I peruse it, and in that effect, I am filing these supplementary counterfeit with your Lordship. In this case, bringing on record the documents available as exhibits during the disciplinary proceeding, your Lordship, and an original record is also here, your Lordships, for your Lordship's perusal. And I have served a copy on my friend, your Lordships.
What is your answer?
Yes, I have done. In the supplementary affidavit, your Lordship, wherein I have brought in.
No, first of all, whether inquiring officer has maintained the day-to-day order sheet.
Your Lordship, that was what has happened, your Lordship, as your Lordship have perused it earlier, the file that contains the attested copy, attested on one particular date by the then SSPO.
Sir, what is the question?
Yes, I'm coming to that. I have understood. I'm coming to that. But your Lordship, that order sheet is not there. Neither the attested copy of the order sheet is there.
No, order sheet is maintained or not?
That must have been maintained, but it is not.
No, you can't say. You presume. We have specifically asked you.
No, that has not been answered here. But it is said that order sheet is not available. When I put a direct question, a query.
No, sir, you have only one answer. Whether order sheet is maintained or not.
Your Lordship, as you're following from your Lordship, presumably yes.
Where have you said in your pleadings?
No, we have not said it in this.
Then it is silent means you are admitting that the inquiring officer has not maintained the order sheet.
Your Lordship may presume so, but.
Then where is the marking of withdrawal application as an exhibit?
Yes. I have annexed those there in your Lordships, and those are here, your Lordships.
It is exhibited as what?
Yes, your Lordship. I'll in that we have said it. That we have said it. Your Lordship may peruse.
Annexure R2 has been marked.
Yes.
As exhibit what?
Yes. Exhibit S. Withdrawal slip as SB7. That is when the year it was closed of 2006. And exhibit 8 and 9, the course of the inquiry. Also, all these have been marked, your Lord.
Correct, sir. Where is the marking exhibit? This annexure R1 is marked, R1 and R2 are marked as exhibit A, B, C, D. What, sir?
Yes, your Lordship.
Where is that?
I'm coming to that. Your Lordship, may peruse it from here. In fact, your Lordship, the inquiry report is also there.
We are not concerned with that. We are concerned with whether this particular document has been marked in the inquiry proceedings or not. I think the department has not assisted you properly, or you have not gone through this paper.
Yes, I'm coming to that, your Lordship. Internal page 16, your Lordships, of this document which I filed today, submitted today. The inquiry report, the 2.1, the following listed documents were exhibited on behalf of disciplinary authority, and the exhibit mark given therein are hereunder. And these are the exhibits we are relying upon. And those were, your Lordships, those were 3.2 with the NSC agent confirmed the genuineness of following document. That has all those documents, your Lordships. And then during the examination of Chief
Ansuman,
yes.
How you are able to show that this withdrawal slip has been prepared by the appellant?
Whether handwriting has been.
I'm coming to that. In this inquiry report says so, your Lordships. Your Lordship, I'm extremely handicapped because the original records are not there. So I have to be dependent on these only, your Lordship. I'm coming to that. Your Lordships may peruse internal 4. Neelam Srivastav, SW depositor of account, denied the signature on S8 and S9 and payment date 13/8/2007. The original account holder denies.
No, mere denial, correct.
No.
How are you fixing the responsibility on the petitioner?
Yes.
She was not made witness.
No, she is a SW.
All right, sir. How did you come to the conclusion that these withdrawal slips are prepared by him? Whether handwriting experts have given verdict?
Your Lordships, in the whole proceeding of inquiry report, your Lordship will say during that the cross-examination has also taken place.
You are not answering.
Yes, I'm coming to that. I'm coming to that. What my friend said, she has done, that's why I've said it. Because the petitioner had an opportunity to cross-examine her. What was my submission on in between, Your Lordship? Let me place this bottom of page 18, Your Lordship. Srimati Neelam Srivastava, SW, deposit of account, denied her signature on S8 and S9 and payment dated 13/8/2007 in respect of closure of both accounts. Srimati Neelam informed the fact in presence of PRIP and her application dated 13/5/2009. She also addressed the undersigned with the application dated such and such and reiterated the above fact. Sri Sushil Kumar Sinha, he is the NSC agent, and
This, sir.
I'm saying who are the people who supported
You are making charges against the petitioner.
Yes.
That he is involved in this fraud transaction.
Your Lordship, the story is that the account was closed. And then after 1 year, it was, and he...
Sir, all right, story is all right. How are you fastening liability on the petitioner?
I'm coming to that. He was in charge of that ledger. He was in...
No, mere in charge is not sufficient.
No, and withdrawal, there are no check system in postal account, There are withdrawal slips. And he has to release the withdrawal slip or the is available in the post office. As far as functioning, we are aware of it, Your Lordship. So neither the account holder had a check.
So you are not able to convince this court how the fastening of liability on the petitioner.
Not at all.
Then you please come straight away come to that.
Yes, I'm proceeding, Your Lordship. I'm proceeding step by step, Your Lordship. Lordship may just bear with me for some time, Your Lordship. Sri Zainuddin SRU has also stated that a deposition, that signature of in their deposition, that is signature of Neelam Srivastava put on SB7 dated 13A is not tally with the put on SB3 or specimen signature. The last withdrawal signature and this withdrawal signature.
Sir, we are totally in whatever your argument we accept. Show us the material to show that directly the petitioner is involved in this transaction.
As per Article 3, did not check the pages of TD long book. That's the last on page 19. At the time of taking over charge of the office officer required to check important and accountable paper and not checking pages. Mr. Shah violated the provisions of the rule in the written brief, and he has also admitted that, Your Lordship, his WS is also here. It's mentioned that pages containing entries of closure of ID account under the data has been turned out, and it is no absolute as the pages.
Who is this Sushil Kumar Sinha?
He is an NSC agent, a National Savings Certificate agent. He is the agent who sells this is National Savings Certificates, and he gets some commission.
Certain checks. Yes. Come to number. Your annexure R by 9, 32.
R by 9, page 32. Page, Your Lordships?
32 of your.
No, this is.
Went through.
Through him, an agent, NSC agent.
Checks issued.
The number of checks issued 1 to 72. No. I am saying this withdrawal, subsequent withdrawal was on a withdrawal slip.
You said so.
No, Your Lordship, this account was closed 1 year ago and then it was operated by this petitioner.
What is the date of closure of account?
13, yes, Your Lordships. In 2006 it was closed.
5/9/2000.
2010-2006, Your Lordship.
You're not appreciating what is the evidence against him.
Your Lordships, in my humble submission, the account of these two account holders were closed in 2006.
So those are all things, sir.
And he was,
How it has been linked with the
it was in the custody of this petitioner, and he operated it, and he has done this fraud and committed.
No, at the best you can fasten liability that there is a negligence on his part, but not that he is. He has played a fraud.
Yes, let me just place one more document, Your Lordship. My annexure R/7, page 26 to 27. His WS. Petitioner's WS.
26.
26 to 27. It is in a Hindi, Your Lordship, so I'm sorry for that. 13/8/2007 को.
26. Not there.
Yes, this page, Hindi page, Your Lordships. Lordship here. The date at the serial is.
Thereafter it is there.
The page number is not there.
Yes, Your Lordship, it is written here. दिखा दीजिए.
It's noted.
No, Your Lordship, because we don't want to cut the document at the top. हम बताते हैं.
अरे हम क्या बताएंगे, आप तो 30 पेज पर लगा दिए हैं और 24 को सबसे नीचे.
I'm sorry. I'm sorry, Your Lordship. I'm sorry.
Find out your.
No, I'm sorry, extremely sorry. Lordship, just pass it over. I'll get it. Page.
में तो नहीं है कि दाहिना से बायां पढ़ना है.
नहीं, जी ना, हम गलती हुई है. हम ये भी नहीं कहेंगे कि मेरे क्लर्क से गलती हुई है, लेकिन हम कर देते हैं. अभी ठीक कर देते हैं.
After page 27, 32.
I'll just get it. I'm sorry, Your Lordship. I will not disturb the affidavit part. I'll give the pages which I'm referring to. I will not disturb the affidavit, Your Lordships.
All right, what is this, sir?
Yes, this is his admission.
Whose?
Petitioners, yes.
To what extent he has admitted that he has played fraud?
That's why I'm placing it, Your Lordship. Let me place it. वो अपने कार पर उपस्थित था.
Please straight away go to this sentence that he has admitted in the fraud.
उक्त दोनों टीडी खाताओं का क्लोजर संबंधित लेजर में मेरे को द्वारा दिनांक 13/8/2007 को क्लोजर दिखा दिया गया इनको. He had seen it on the day he has taken charge.
That just now you have submitted that he has admitted the alleged charge. Where is the admission? Don't circumvent.
No, I'm not, Your Lordship. He admits that the account was closed and thereafter he has operated the account.
So charge he has not admitted. He is saying that I am the custodian of that particular section. That's all.
No. He says that the account was even closed and then thereafter it was operated upon.
Therefore, it is only negligence on his part. He has not played fraud because that has not been proved. You should have sent the material for forensic verification of handwriting expert or something like that.
Lordship, not in so many words, but he has admitted his guilt.
But he has not admitted the fraud.
Obviously, Your Lordship, I put a question to myself that if an account is closed by the account holder and then thereafter.
Correct, there is a negligence on his part.
No, let me complete, Your Lordship. If that account is operated after the closure by the account holder, and if that account is operated, withdrawals are made, and which has caused the loss of revenue to the department, and the petitioner being the custodia legis of all the documents, especially the sensitive document, which in my humble submission, account papers in a post office are sensitive because we are not only
Sir, there are two things, sir. One is negligence, another is fraud. Whether fraud has been proved or not.
My humble submission, yes.
Show us the material.
Yes, it is his own admission that after closure.
No, sir. Sorry.
Your Lordship, these are my humble submissions.
All right. What is the penalty?
Lordship may remand it to the appellate or the revisional authority to look into the.
Have you initiated criminal proceeding?
No,
No, when you have come to the conclusion that there is a fraud played in the transaction, why you did not initiate criminal proceeding?
Your Lordship, I have not been briefed on that, and I think that has not been initiated, but it is not so candid.
What is the penalty?
My lord, recovery of rupees 63,509,
63,000?
509, and withholding of his next increment for 2 years without cumulative effect.
Very reasonable penalty. Penalty is very reasonable. If it was a dismissal from the what are the grounds in support of your?
First is, my lord, the main witness, my lord, Neelam Srivastava, whose signature was in question, my lord. Whose signature is in question, my lord. Mrs. Neelam Srivastava. She was not made witness.
No, we are agreeing that there is no fraud on your part because there is no evidence. Now question is negligence is there.
That
Due to negligence, you are liable for this 63,509. That is recoverable, correct? And without of 2 increment.
second punishment is asked.
No. Withholding of 2 increment. In fact, disciplinary authority has taken very lenient view, having regard to the charges.
Charges was not fully proved, my lord.
Correct. That is the reason we are saying that. Otherwise, it is a case of dismissal from service. If fraud was proved, fraud is not proved. Anything else? Neelam, Srimati Neelam was not examined,
My lord.
not cited as.
There was no handwriting expert opinion was there, my lord.
Have you taken such contention?
My lord.
All right, this is relating to fraud only.
That is
Only 2.
Sri Ajay Kumar was also not examined in the. Sri Ajay Kumar was husband of the Neelam Srivastava. He was also not.
Then that is relating to fraud.
All is relating to fraud, my lord.
Taken. But in support of negligence, you have not stated anything. Petitioner invoke section 19 of the Administrative Tribunal Act 1985 and filed original application number so and so before the CAT, and it was rejected
2018.
on 30th August 2018, hence the present petition. Next, on counsel for the petitioner vehemently contended that the alleged fraud relating to withdrawal of a sum of rupees 63,509 from the account of Srimati Neelamma and Sri Ajay Kumar is not proved, and it is required to be proved on due examination and cross-examination of the account holders, namely Srimati Neelamma and Ajay Kumar, and they have not been cited as witnesses to the departmental inquiry. Further, we have noticed that for the alleged offence, penalty is only recovery and withholding of 2 increment without cumulative effect. Imposition of withholding of 2 increment without cumulative effect is a minor penalty. Recovery is permissible for the reasons that there is a negligence on the part of the petitioner in not noticing the account properly while withdrawing a sum of rupees 63,509 to that effect, he is liable for the order of the disciplinary authority insofar as recovery is concerned. It is in order. Therefore, no interference is called for insofar as disciplinary / appellate authority and order of the tribunal. Accordingly, writ petition stand dismissed.
Extremely obliged, Your Lordships. I'm sorry for the inconvenience, Your Lordships.
What you should state to the point.
Your Lordships.
You should not circumvent.
When the record is not there in the order.
Then you should be state admission. You are assisting the court.
That's why this affidavit.
No, you are a law officer of this court.
Yes, that's why I've admitted in this affidavit that the records are not there and it is attested copy. Obliged.
Yes.
Final hearing CL number 1 along with connected matters. Sri Atul Kumar Shukla, Sanjeev Kumar Misra.
These matters have come up. Lordship, may I just mention about before my senior to proceed in this bunch of the cases, Lordship. In one of the matter, Lordship, I filed the reply on the part of the Government of India. There has been other cases which has been tagged together, Lordship. I have paid out the reply in respect of the other cases also. Difficulty is that, Lordship, my name has not been reflecting even in that matter also in which I have filed the reply. So I just could not come to my notice that the matter has been listed today.
Listed since 2 weeks. No, this SLP is pending in respect to which order?
Against the
I have
order
the
of
orders.
Your Lordship
Has the order of 27 to 23 order.
27 to 23. Yes, my lord.
So it says that some SLP is pending, but that will not come in way of the High Court. But which SLP against which order?
Against the order passed by the Hon'ble High Court of Karnataka, Your Lordship.
Against?
My lord, SLP would mean the same SLP, my lord. This special leave petition, not any other.
No, that is against which order?
Yes, against an interim order passed by this Honorable Court.
This court?
Yes, yes. My lord,
Which order?
I'll give the background.
Which is that interim order?
I'll just give the background. My lord,
Passed in this case?
my lord, the order is in National Commission for Homeopathy matter. I'll give the serial number. This order.
It might be in 1.18.
1730 देना?
नहीं 1.18 नहीं है.
पहला केस तो वही है.
WP 1730.
National Commission for Ask me just देखो.
Which is that 1730 in that order is passed?
1730 is 1.19.
1.19 then?
Yes, 1.19. Yes. There are other orders also. Once your lordship sees this order, I'll show the other orders, mirror.
तो कौन सा interim order था इसमें? 2522. ये तो W है.
24th January 23. Saying that identical cases are pending and similar relief.
No, this is some chief general manager versus Baidyanath Singh.
No. ये गलत आ गया.
57.19.
No. 57.19.
These are 1 point.
1.9, my lord. 1.19.
1.9. ये वो रेगुलर लिस्ट का ले दिया.
नहीं ये तो डीबी की स्पेशल लिस्ट आई है.
हाँ.
उसका 0.19 है स्कूल ऑफ होम्योपैथी.
तो उसमें इंटरम ऑर्डर क्या हुआ था?
उसमें इंटरम ऑर्डर ये है, मतलब ये जो 19 वाला केस था, दिस इज पर्टेनिंग टू एकेडमिक सेशन 22-23, दिस सेशन. सो इन द प्रीवियस सेशन, द इनिशियल केसेस इन द बंच, देयर इज एन ऑर्डर दैट द सीट्स व्हिच रिमेन अनफिल्ड आफ्टर द नीट क्वालिफाइड हैव टेकन एडमिशन should be allowed to be given admission by the colleges. That was the order. So in this case, the same order has been followed for the current academic session also. But for this, my lords, will have to see what is the initial order passed, my lord. Initial order is, my lord,
1.7.
1.1 निकालना बाबू साहब, उसमें first order है.
24.1.
4609 is 1.1. So probably what interim order my lords are reading, that refers to the order of 4609. That is 1.1 today. So 1.1 will have a detailed order.
All right. So that order passed in an earlier petition as regards 21-22 was followed for 22-23 also.
Now, with regard to 21-22 orders.
So, but there is no stay of the Supreme Court.
No, there is that stay, no.
Huh?
Wait, 27-2 के order में ही stay है.
Until further orders, there shall be stay of the impugned order. So this 24-1 is stayed.
Yes. Why that is stayed? In the first bunch matter.
Who had gone to the National Commission for
Now,
Homeopathy?
in the 21-22 matters, against the same interim order, Commission went to Supreme Court. Now, this was the order passed.
Anyway, we'll have to finally hear it.
But the background lordship should know, my lord. I have no problem.
Should we finally hear it today?
Yes, my lord. What I'm showing is, my lord, lordship may just see this order.
So then please start your argument so that we can at least.
Lordship may see this order.
We may not be able to complete it today, but we'll mark it part heard and then
Very well.
sit on some other day also.
Now, my lord, against the 21-22 session orders, they went in SLP commission and this was the order passed. And this order was, my lord, dated 17th October 22. This order said that we request the High Court to decide the matter, preferably in 6 weeks. So that October order with a request to decide in 6 weeks, these are the matters remaining in the first initial 5-10 cases of this bunch, my lord. Now, thereafter, my lord.
Within 6 months.
6 weeks, my lord.
6 weeks.
इसलिए मैं बता रहा हूँ वो अक्टूबर का ऑर्डर था. अच्छा, उसके बाद सर ये हुआ एक मैटर उस बंच में छूट गया था. When that SLP came up for hearing, this was the order passed on 10th February 23. When probably Supreme Court found that the matters are still pending. 10th February 23. And there they said, we have obtained an order and are not cooperating with the disposal of the petition in the High Court. And then we dispose of the SLP with request to the High Court to decide as expeditiously as possible within preferably 6 weeks from today. However, we clarify that in the event respondents indulged in protracting tactics, the petitioner herein, that is the respondent before the High Court, would be at liberty to apply for vacation of stay. And if such application is filed, same shall be considered by the. So there they projected that we are avoiding hearing.
6 weeks.
And the Supreme Court had to write that.
That week of March. All right, so we'll hear it.
I'll start with. Now, Lordship may, my lord, kindly take up 1.13 as
1.13
in the present matter.
In that, who is for the other side?
My lord,
I appear for National Commission for Homeopathy.
Pleadings are complete. Your file, your reply, rejoinder, everything is on record.
Filed my reply in
Once the argument starts, then we will not give you any time for completion of pleadings.
the main matter in which the main interim order was passed. In other matter, my lord, I'll have to adopt my reply.
You have adopted?
Filed the formal application, but I am willing to adopt it.
We'll record your oral submission that you are adopting that reply.
Aditya Sanji, Mr. Aditya Sanji appears.
Nobody, somebody else appears.
National Commission of Indian System of Medicine. There are two categories of matters. One pertains to admission in homeopathic colleges.
Please use the mic.
Lord, there are two categories of matters. One pertains to admission in homeopathic colleges. Another pertains to admission in Ayurvedic colleges. Lord, for homeopathic colleges, my lord, I am the contesting respondent. For Ayurvedic colleges, my lord, Mr. Aditya Sangi is the contesting respondent. My lord, he is not here.
He is not there.
He is not here.
So in your case, who is opposing you, Mr. Nagaraj?
Both, my lord. I am appearing in their paramaterial.
No, the council is not present, or the council is present is opposing you.
I am appearing in homeopathy also and Ayurveda also. So it does not matter.
No, you've picked up one case.
Yes, in that
pertains
case,
to
it is homeopathy, my lord.
homeopathy.
My
So
friend
they are
is-
there.
Yes.
All right.
You know,
Yes,
so the simultaneous use of homeopathy and Ayurveda have side effects.
Paramateria, my lord. Paramateria.
You'll also just may kindly appreciate lawsuit.
It had a bad side effect on us, my lord.
No, that is what they call it. Medica or something. What? Materia medica in homeopathy.
You'll also just may kindly appreciate my sons. I have already filed the reply in WP number 9340/2020.
We are taking up 1730.
No, it also
0.19.
9340. WP 9340/2022.
Which item number?
My lord,
The estimate is 1.5.
I am requesting for 6199 of 22. Item 3, my lord. 1.3, my lord. We have made a compilation of all the regulations.
So far as
1.3 these.
Yes.
So also, so far as the cases which has been in relations to Ayurveda College, Lordship, the reply has been filed, and in relations to other cases also the reply has to be adopted. But for the homeopathic colleges, Lordship, I have to file the reply.
No, at least start. We will not be able to finish today, but let us start at least.
But Lordship, the reply has not been filed in relations to the homeopathic college.
Where reply is filed?
No, I filed the reply in relation to the Ayurveda college.
No, in this, we are talking about 6199.
No, Lordship, reply is not there. I'm just seeking a time to file the reply.
Homeopathic college.
Yes, Lordship. No, I'm representing the government of India, Lordship, because they have challenged the. So I'm just simply just appraising to this honorable court, Lordship, that we have to file the reply in relation to the homeopathic college.
They go and tell the Supreme Court that respondents have obtained interim order and not cooperating, and they get it written in the Supreme Court that if we protract the hearings, the High Court should consider.
Mr. Nagaraj,
and
please.
now here they have audacity to ask for time, my lord.
Mr. Nagaraj, please start your argument.
Yes, my lord. I'm here to argue. My lord, this we have made a compilation of all the regulations and all the acts, my lord, at one place, so that my lords, it does not contain any other document except the regulations and the acts, my lord.
Yes.
My lord, the issue here is, my lord, and the broader issue is, my lord, the broader issue before your lordship is, my lord, there is a entrance examination called NEET, my lord. That NEET is designed and structured for MBBS and BDS. Now the question is whether that NEET can be a source of admission for other courses like Indian system of medicine, homeopathy, and in Indian system of medicine there are Ayurveda, Siddha, Rova, Sikpa. There are so many other modes of medicine, my lord, and treatment. So the broader issue is only this. Whether this NEET, which is going on, would be the source for giving admissions, and those who do not give that NEET will not be entitled to get admission in Ayurveda. These matters, my lord, pertain to year 21-22 and 22-23. My lord, earlier there was a Homeopathy Act of 1973 that stood repealed Wide Act of 2020. So these matters are pertaining to 21-22 and 22-23 after the enactment of 2020 Central Homeopathy Act, my lord. And in this compilation, lordship would see page number 41 is that act, my lord. Now it is called, my lord, National Commission for Homeopathy Act, my lord. Lordship may turn to section 14 at page 45. And this is the crux, my lord. 14 says...
45 is part of the rules.
No, my lord. Page 45 is section 14 of the Central Act, my lord.
Oh,
Of compilation, my lord.
The compilation.
They have made compilation of all the... Yes, my lord. That is a convenience compilation only, my lord.
Yes.
My lord, the act starts at page 41.
Yes.
That is the National Commission for Homeopathy Act 2020.
Yes.
And I'll take to the other provisions later on. Please come to 14, my lord, at page 45.
Yes.
14.1 says, there shall be a uniform national eligibility entrance test for admission to undergraduate in homeopathy in all medical institutions governed under this act. The commission shall conduct national eligibility cum entrance test in English and such other languages through such designated authority and in such manner as may be prescribed. 3. The Commission shall specify the regulations, the manner of conducting common counseling by the designated authority for admission to all the medical institutions governed under this Act, provided that the common counseling shall be conducted by the designated authority of central government and the state government. Coming to 14.1, my lord, there shall be a uniform national eligibility cum entrance test for admission to the undergraduate in homeopathy in all medical institutions governed under this act. Now turn to the definitions, my lord. Medical institutions is defined at page 42, section 2J. Medical institution means institutions within or outside India which grants degrees, diploma, licenses in homeopathy. Kindly mark this, my lord, in homeopathy, and includes affiliated colleges and deemed to be universities. So under 14.1, it contemplates a uniform NEET for undergraduate courses in homeopathy. It's absolutely clear, even otherwise, without going into the definition of what is meant by medical institutions. So there will be a uniform NEET for homeopathy for institutions covered under this act. Now, medical institutions is also defined that homeopathy and other allied to homeopathy. It will be conducted by the commission. Commission is also defined. 2D, my lord. Commission means the National Commission for Homeopathy constituted under section 3. So, my lord, after 2020, the law requires that for homeopathy colleges, there will be a uniform NEET for homeopathy colleges, and that NEET will be conducted by the commission. That is the Homeopathy Commission. No, I do not think, my lord, there is any ambiguity in 14.1, my lord. And this is the crux of the matter, my lord.
What was the position prior to 20?
Prior to 20, my lord, would not be relevant, but still I'll take your lordships to 1973 Act. But then, my lord, outset I said, present case before your lordships is session 21-22 and 22-23. My lords may for reference go into the prior history, but for deciding these cases, after 2020 Act was enacted, 14.1 absolutely clearly stipulates that there would be a uniform test amongst all homeopathy colleges to be conducted by the council, that is the Homeopathy Council.
Yes.
Now, I have shown the definition of commission, I have shown the definition of medical institution, and homeopathy is also defined. And section 3, my lord, defines the commission, my lord, how it would be constituted. It is functional.
What was the position prior to this amendment?
Yes. 1973 Act was there, and that your lordship would find at page 28 of this compilation.
28.
Prior to that, my lord, section 28, page 28, that is the 1973 Act. That contemplated, my lord, under section 20.
So you are concerned with which therapy?
Homeopathy and allopathy both, my lord.
Both?
Yes.
No.
They are paramateria.
In this petition?
Homeopathy.
Only?
Only. In this petition only. And then in the bunch, there are other Ayurveda also, my lord, under the Indian System of Medicine Act 2020, which is paramaterials.
There are admissions to both the kinds of colleges.
The lordship would have a look at the list.
In
half
some
of the
petitions
colleges,
it is homeopathy, some petitions it is Ayurveda.
half of them are homeopathy and half of them are approximately
Ayurveda. All right.
Now, my lord,
Now, if you come to the repealing section, 58, it talks about repealing of Indian Medicine Central Council Act and the Central Council of Indian Medicine. Page 55. So prior to 20, there was a separate act for homeopathy.
73.
And for other fields of medicine, it was the Central Act, Central Council.
Their own separate 1978 Act. Indian System of Medicine Act, covering Ayurveda, Siddha, Unani, those courses.
All except allopathy and homeopathy.
No, we got two broad streams. Allopathy not involved here. One is homeopathy, Special Central Act. Second is Indian System of Medicine, separate act covering Ayurveda, Unani, Siddha, so and so.
Right.
So there are two broad segments of.
What is the Central Council of Indian Medicine Act?
That covers, my lord, Ayurveda, Siddha, Unani, so and so.
No, why two acts?
Because homeopathy is separate act and Indian System of Medicine is separate act. Homeopathy is concerned only with homeopathy. And Indian System of Medicine is concerned with Ayurveda, Siddha, Unani, other courses.
If you come to 55, section 58, 1 says, these two acts stand repealed. All right, we'll see. Yes, please proceed.
Now, my lord, after 2020, position prior could be, my lord, and lordship would see, my lord, page 56 of the compilation, that is the Indian System of Medicine Act 2020. Since they are paramateria, my lord, I'll refer to the Homeopathy Act only, my lord, page 41 and page 48, my lord. Lordship was at section 58 at page 47.
Yes.
Please see 59, my lord.
59. Yes.
The commission, page 48, running page, my lord.
Yes, yes.
The commission shall be the successor interest of the Central Council of Homeopathy, including its subsidiaries, organ trust, and all assets, liabilities of the Central Council of Homeopathy shall be deemed to have been transferred to the commission. 2. Notwithstanding the repeal of Homeopathy Central Council Act 1973, the educational and medical standards requirement and other provisions of Homeopathy Central Council Act 73 and the rules and regulations made thereunder shall continue to be in force and operate till new standards or requirements are specified under this act or the rules and regulations made thereunder. So when 2020 Act came into picture, there were, my lord, previous regulations.
All right, so this says that it has to be admission, has to be through the NEET qualified candidates. Yes.
Delhi High Court in one interim order read only one word uniform. Section 14(1), it read, picked up one word of uniform and said uniform means the NEET already which is happening, ignoring the language which is crystal clear for homeopathy colleges conducted by the commission. Other side would refer to that order, interim order, have said. But then my submission here was that after 2020, and 59 would have some relevance because 59(2) says that the rules and regulations would continue to be in force.
So, Mr. Nagar, first let me ask you that question. What do you want from this court?
Broader question, I started with that. That the issue is whether admissions to homeopathy and Indian system of medicine courses will be through the NEET which is going on for MBBS and BDS or under section 14 of the 2020 Act of Homeopathy as well as Paramateria Act of Indian System of Medicine.
No, 14 says NEET.
The word is NEET. It's a generic term. Just like in our times, it used to be any medical college, PMT and PET. You are preparing for anything, it used to be medical and PMT and PET. So the NEET is a generic word.
No, you want admissions to be done out of which? Not from the NEET list, but?
The NEET to be conducted by the Council of Homeopathy for this purpose.
So you want that there should be multiple exams.
This is what
students securing admission to the MBBS, BDS, homeopathy, veterinary, Ayurvedic or other Indian system of medicine courses. They should appear in multiple exams to be conducted by different agencies. Then we'll come to the moot question. What is the syllabus prescribed for appearing in these entrance examination? Whether you appear with the same 3 subjects, biology that comprises of zoology, botany, physics and chemistry, or there are other subjects prescribed, say for Indian system of medicine, you are required to appear in Sanskrit or in some other paper. You'll have to show that also.
Yes. Milord, first thing, Milord.
So NEET is conducted under certain provisions. Is there any statute for
under the
conduction of NEET?
They have framed regulations now, which I have complied with. Regulations are on record. Milord, if section 14(1) anywhere indicates...
I think the answer would lie in that NEET, the provisions governing the NEET exam.
Lordship would see page 88 of the compilation, where now they have framed regulations, page 89.
So regulations of 22.
Yes. So this is not what we want. This is what the law wants. That as per section 14, there has to be a separate NEET for homeopathy to be conducted by the Homeopathy Council. And our submission stands, my lord, not only fortified, but answered by page 89 regulations framed called Bachelor of Homeopathy Medicines and Surgery BMHS Regulations 2022. Please see 4.2, my lord. There shall be a uniform entrance examination for all homeopathy medical institutions, namely National Eligibility Entrance Test for admission to the undergraduate courses in the medical institutions in each academic year, and shall be conducted by an authority designated by the National Commission for Homeopathy. So it is the requirement of law now. My lord, 14(1) was itself sufficient. But now the regulations have been framed that there would be an exam, unfortunately called NEET, which is creating all the confusion. And that NEET would be conducted by National Commission for Homeopathy.
This means that there will be a common national this entrance examination, national eligibility cum entrance examination, and various regulatory bodies, be it homeopathy, Ayurveda, or the English system of medicine, they will be sending requisition to the common body to conduct examination to select the candidates to be admitted in their respective colleges.
Now, had it been the situation, Milord, or the intention, Milord, under the Indian system of medicine,
Because this is the meaning of this clause 4(2). उसमें कहते हैं, there shall be a uniform entrance examination for all homeopathy medical institution, namely NEET, for admission to undergraduate course in medical in each academic year, and shall be conducted by an authority. Otherwise, there was no need for saying this. Authority designated by the National Commission for Homeopathy. So, National Commission for Homeopathy can designate the authority, that is the authority which is conducting.
What is coming from your lordship is that the National Commission for Homeopathy may say that the NEET being conducted by for MBBS would be the NEET for admission. But, my lord, for Indian system of medicine, they have already conducted a separate exam for one of the streams. We have filed that. So that is an answer to your lordship's query. If the intention here was, my lord, somebody...
Right now we are dealing with homeopathy. When we come to that, as far as homeopathy is concerned...
I'm just answering. Homeopathy has not conducted a separate exam,
Yes.
but Indian system of medicine, in one of the streams, they have already conducted a separate examination for their own stream.
So according to you, under this regulations, there is a provision that the commission would be shall be conducted by an authority designated by the Commission of Homeopathy. That has not been done.
Just like PSC conducts examination. So National Commission for Homeopathy may not itself conduct. It may ask some examination body to conduct it.
Right.
That does not mean that there would be a NEET which is already designed for MBBS and VDS would be the NEET for Unani and Siddha.
So what is the disadvantage you face because of this?
My lord, the level, standard, everything is different. The situation is, my lord, that in all the homeopathy and Ayurveda colleges, out of say 100, there are hardly 10-15 admissions through the actual NEET, the MBBS NEET. Because I want to be a cardiac surgeon, I will not appear for Unani and Siddha. If I am of the level of Unani and Siddha, I will not appear for, somebody is wanting to do a diploma course, he will not appear for IIT. That is the difference. That the exam is structured like that.
What was happening prior to coming into effect of this 22 regulations?
There were regulations of 2018.
Where is that?
I showed your lordship section 59, which said that until regulations are framed, notwithstanding the repeal, the earlier regulations will continue. So in 2018, there were regulations framed. The regulations provided for a general NEET, my lord, without specifying, because 2020 Act was not there. And 73 Act did not provide for a separate NEET for homeopathy. So 2018 regulations said that it will be through NEET. There was a challenge throughout the country. Karnataka High Court set aside those 2018 regulations. One matter went to Supreme Court. Supreme Court decided the SLP, my lord, on two grounds. One was whether they have power to frame such regulations or not. One. And second was whether these regulations have been validly framed under 22, subsection 2 of 20, there is a requirement that once regulations are framed, they will be sent to all the states, which are the stakeholders, for their comments. And only after those regulations would be framed. Karnataka judgment is also on record. I'll show that. First, your lordship would just see, my lord, the...
Mr. Nagrat, our question to you was that prior to coming into force of these new provisions,
2020 Act.
2020 Act, how admissions were made to various homeopathic colleges, because PMT stood abolished long back. Then after PMT, there were two different forms of exams which took place before coming into force of NEET.
My lord, in MP, there used to be an examination conducted by the state separately for Ayurveda and other courses. Not through the PMT. It was called PAHUT, my lord. PAHUT.
That was prior to coming into force of NEET. 2018-19 में क्या हुआ?
मिलट 18 में जो रेगुलेशंस आए थे वही मैं
व्यापम ने एग्जाम कंडक्ट किया. PAUT used to be conducted by व्यापम.
yes for these courses not
Earlier.
yeah, for
They
those
were conducting PMT
separately. So the same reason I am answering your lordship's question. What is the problem in appearing in the NEET? The problem is the same which was through PMT and PAHUT earlier.
And then that brings us to the original query which I had put to you. That whether the syllabus for entrance examination for these three streams of medicine is different for a student pursuing or possessing 12th class qualification, that is higher secondary qualification 10+2 with science subjects is only entitled to appear for these courses. Because unless you answer that.
Milord, the qualifying is 12th.
Qualifying
so it is the same.
Subjects are also the same.
Yes. Milord, it is like appointing Tehsildar through UPSC. Saying that what difference does it make? You appoint a Tehsildar through UPSC.
For your information, Tehsildar is still appointed through UPSC for union territories.
Agreed. Milord, what I am saying is there is a level of difference in the structure of the examinations. That is why, Milord, prior to 18, there was a PMT and there was a special examination conducted. In 2018-19, there was a controversy. I'm just showing what is the controversy.
Nagaraj, if you come to this syllabus of this NEET, 142.
Yes, Milord.
It's a very generic kind of a syllabus. It is not specific to any allopathy or homeopathy. But it says physics, chemistry, botany, zoology.
This syllabus is provided by National Medical Commission. That is the different act for MBBS. That is the difference.
That is for allopathy.
No, that is for MBBS.
Allopathy.
No.
Allopathy stream of medicine.
Yes. Yes. Page 142, Milord.
Well, you have to have that minimum proficiency. They are only testing the minimum proficiency in these general subjects, which will be used by students of all the therapies. Whether it is allopathy or it is homeopathy or it's Ayurveda.
There is no quarrel with that.
So this common entrance test only tests that minimum standard whether you have it or not. And then you are studying and you are taught that particular field when you enter.
And then the orientation is also different. Orientation is student-centric, where a student is not harassed to take different examinations at different point of time, putting in lot of pressure and anxiety and depression and so many things on him. He takes one exam. On the basis of the ranking, he goes according to the merit.
But then, Milord, that would mean section 14 would have to be read to say that it is the same NEET which is being conducted, not by the commission, because language of section 14 read with the regulations now framed. If your lordship
now the exams have been held. No. NEET test has been held.
Yes, for 22-23 it has been held.
For 22-23
it's been held. So there is an interim order.
And admissions have taken place.
Yes, there is an interim order. Unfilled seats.
Who has conducted that NEET?
National Testing Agency.
Same body.
So that's why there is an interim order that those unfilled seats, because colleges got 10 seats out of 100 through that NEET, because nobody appears, Unani, Siddha, Ayurveda. So there is an interim order that who are otherwise qualified on the unfilled seats, after all the NEET qualified.
Qualified means there's some passing marks.
50% is the benchmark.
50% benchmark.
So the admissions cannot take place if somebody has secured less than 50% in NEET.
Not NEET. But after the NEET qualified have taken, this is the interim order, that after the NEET qualified have taken admission, the remaining seats will be filled at the college level. That is the...
From the NEET list?
No, beyond the NEET list. Otherwise...
How can you go beyond the NEET list?
Because 2020 Act says there has to be separate NEET, and which is being held in different courses, other courses. So if your lordship...
2020 Act also says NEET conducted by a particular body. Now it has not been conducted by that body, but by some other body, which was the arrangement earlier.
But Homeopathy Council has not said that the NEET being conducted for MBBS would be the NEET we have authorized for admissions in this. That's not their case.
What is their stand?
Their stand is that
the commission stand.
Milord, they are sticking on 2018 regulations.
Mr. Nagaraj, had you been standing for the students, then your anxiety that students will not be getting a fair chance to compete, will be biased or prejudice their interest, would have been taken care of. Standing for the colleges, your stand has to be more rational, and you will have to put in more material to justify that what you are going to gain, how you are interested in the whole scheme of examination, because your relationship with the student is that of a teacher and a taught. You are only there to impart, maintaining the standards prescribed by the respective council. So your interest, you're coming here, vis-a-vis students coming here, seeking for a relief, that anomaly is to be reached out.
We have set up colleges. The seats are, yes, obviously, my lord. I cannot even for a second deny that. I say, my lord, if I have 150 strength, 20-30 seats are being filled, otherwise 80% seats are going vacant only because...
No, why are they going vacant?
Because there is no NEET candidate available. No NEET candidate available.
No, there are lakhs of people sitting in NEET.
Still no NEET. Nobody opts for...
Is there a passing marks in NEET?
If I have...
For admission?
If I have to become a surgeon, I would not take admission in...
50% होना चाहिए रेगुलर.
No, 50. वो तो 12वीं में नहीं वो तो 12वीं में होना चाहिए.
तो ऊपर वाले जाएंगे. हाँ. मिनिमम 50 वाले फिर होम्योपैथी में.
नहीं वो तो 12वीं में होना चाहिए. To sit in NEET 50%. 12वीं में you should have 50%.
तो वो हाँ
मतलब ये चाहते हैं कि 12वीं में जिनके 50 नहीं है उनको भी भर्ती कर लें.
हाँ इनका ये है कि क्योंकि सीट खाली जा रही है.
नहीं वो नहीं 50 से ऊपर मतलब जो नीट में अपीयर होने के लिए 50% जो है उसके ऊपर वालों को.
इसका दूसरा एंगल देखिए ना, अगर नीट मैंडेटरी हो जाती है तो आज स्टूडेंट्स इसलिए अपीयर नहीं हो रहे कि भाई मैंडेटरी नहीं है, विल अदरवाइज गेट एडमिशन. दे मस्ट हैव एक्सप्लोर्ड द स्टैटिस्टिक्स फॉर पास्ट years. But when it becomes mandatory, then more number of people will be competing. You will be getting candidates.
But my lord,
और फिर डिमांड एंड सप्लाई भी तो है. आपके होम्योपैथी आयुर्वेद में डिमांड तो इस पर जब से हुआ है, जब से ये नेशनल हेल्थ मिशन ने जो है आप लोगों को रूरल पोस्टिंग देना शुरू किया है. उसके पहले तो देयर वाज हार्डली एनी डिमांड.
my lord, in the last 3 years.
No, the question has not yet been answered. Is there any passing marks in NEET for admission to the course? Mr. Seth, I don't think there is.
Page 10.
There is. Page, Lord, we kindly have this WP 4609. ये 2 नंबर पे लगा.
नहीं इसमें
15.1
नीट का जो रेगुलेशन है वो हमारे सामने है. सो बताइए.
नहीं ये स्टेट ने फिर नीट के रेगुलेशंस के बाद फिर अपने एक रेगुलेशंस बनाए हैं, उसमें मिनिमम फिक्स किया है.
क्या फिक्स किया?
दैट इज प्रवेश के लिए माध्यमिक शिक्षा मंडल मध्य प्रदेश भोपाल की 10+2 प्रणाली से 12वीं परीक्षा अथवा मध्य प्रदेश शासन के स्कूल शिक्षा विभाग द्वारा मान्यता प्राप्त किसी अन्य बोर्ड या केंद्रीय माध्यमिक बोर्ड से समकक्ष भौतिकी रसायन स्वयं प्रत्येक विषय अलग अलग उत्तीर्ण करते हुए संयुक्त रूप से न्यूनतम 50% अंक प्राप्त अनारक्षित तथा न्यूनतम 40% अंक प्राप्त अनारक्षित प्रवर्ग के अभ्यर्थी ही पात्र होंगे.
नहीं, that is different. That is
12th का minimum.
That is the eligibility qualification.
12th का minimum.
That is 12th
Page 179, sir. Compilation.
of your
Compilation.
compilation.
Fifteen point one.
1.2 million.
No, 15.
Yes, my lord. Both read together, my lord.
सर है सर इसमें स्टेट के रूल्स में भी है.
50 परसेंटाइल है, 50% नहीं है. There is a difference between
Percentile.
50% 50%. Even
अनुसूचित जाति के लिए
20% में भी within 50%.
हाँ ये मिनिमम
This
चाहिए.
percentile, it is not percent.
ये मिनिमम चाहिए नीट में अगर आपको होम्योपैथी में जाना है तो.
So in case of general EWS, it is 50 percentile.
Percentile.
And remaining 40.
Reserved.
40 and 45. So you don't get students securing this kind of percentile.
Nobody appears, my lord, because no registrations even, my lord.
So कैसे हो सकता है?
And that is why, my lord, that is why when 2018 regulations were framed.
No, just a minute, Mr. Seth. So There's dearth of candidates securing this kind of percentile in NEET.
It is their grievance that the students don't secure this much mark and therefore they are not getting students. That is basically their case.
No, is it true or not?
होगा सर तभी तो नहीं
Who is appearing? होगा नहीं. Who is appearing for National Testing Agency? Whether National Testing Agency has been made a party or not, because that statistics can be given by NTA only.
No, yes. It is not a party.
नहीं पाते.
तो NTA ही तो देगी ना वो statistics कि कितने स्टूडेंट अपीयर हुए, कितने जो है 50 परसेंटाइल या 40 परसेंटाइल अलग अलग कैटेगरीज में सिक्योर किए, क्या ओवरऑल सिनेरियो ऑफ सीट्स इन वेरियस कॉलेजेस है.
एक्चुअली सर सुप्रीम कोर्ट में जब ये मैटर गया था तो सुप्रीम कोर्ट ने ये नहीं देखना है कि कॉलेज चल रहा है कि नहीं. कॉलेज की वायबिलिटी इज नॉट द इशू. The issue is whether the standards fixed for medical.
That is what I said. We said in the beginning.
So that is there.
We are not college centric. We are student centric. Our approach has to be student centric.
We have to maintain the standards. Minimum standard. इससे अगर कम नंबर कोई ला रहा है तो फिर वो होम्योपैथी भी नहीं पढ़ सकता. ये इसकी मंशा है. तो मतलब अब अभी जब इसको हटा के अपन करेंगे तो वो बच्चा भी होम्योपैथी पढ़ के कल को डॉक्टर बनेगा जो इतने नंबर भी नहीं ला पा रहा. So this is lowering the standards. The writ petitioners will. Their relief.
No, but Mr. Nagaraj, where have you said that you could not find students of this percentage and that is why seats are vacant?
Yes.
Where have you said in your petition?
At least in the current years, we have said it elaborately. I'll just show you. Chart लगाया ना कहीं पे? 5.31 para of the writ petition.
5.31.
It is humbly submitted. If the seats are allowed to go vacant, which is about...
Just a minute.
No. Our question to you is, where is the statistics? This is the generalized statement.
From our college's side of it.
From your college's
Yes.
side, where is the statistics? You will have to come out with a complete set of statistics. How many students undertake this examination? How many had secured under general/EWS category 50 percentile? How many from reserve category were placed under 40 percentile and handicap under 45 percentile? And what is the distribution of seats pan India?
Milord, as colleges, possibly we cannot answer how many appeared, how many distribution. We can only say in our college, how many NEET qualified approached for admission. This is the data as college we can give. But then how many appeared pan India, which category, that possibly...
Oh, that NEET will,
yes, that
will be
possibly
able to provide
we cannot. But yes, we have, Milord, in the, like we have said, almost 80 to 90% seats are falling vacant since last 2 years.
Vacant?
Yes.
And उसके पहले की क्या statistics थी? आप कितने बच्चे ले पाते थे?
जी.
आप इंडिविजुअल कॉलेज में कितने बच्चों ने एडमिशन लिया? जैसे
मिलट जब पाहुट होता था 100% और अभी भी 2 इंटरिम ऑर्डर से 100%.
नीट को ले
So when
उसमें आप नेशनल टेस्टिंग एजेंसी को क्यों नहीं पार्टी बना लेते? और
Milord, in fresh matters we have made. In the 22-23 session, Milord, this current ones.
Are they before us?
Yes. Milord, I'll give
No, somebody is before us for the testing agency.
Who is representing NTA?
Sir, yet not they had filed any makala.
अरे भैया आपने बोल रहे पार्टी बनाया तो
पावर नहीं आया.
नोटिस इशू हुए नहीं हुए?
Notice.
कौन normally any standing counsel for the testing agency?
State Solicitor General can be directed, my lord, because it's a central agency. Or Mr. Vikram Singh can also see.
Mr. Yadav is here.
Your Lordship, just may kindly appreciate one paragraph of the reply which has been filed on the part of the Government of India in WP number 9340/2022.
What is it?
Reply is there, Lordship. That issue has already been settled, Lordship. Yes, Lordship. That the Indian Medicine Central Council Minimum Standard of Education in Indian Medicines Amendment Regulation 2018 bear under challenge before the Honorable Supreme Court in India. In Union of India versus Federation of Self-Finance Ayurveda College, Punjab and others, Civil Appeal number 603/2020. It was alleged by the petitioner therein that the regulation are ultra vires, the Indian Medicine Central Council Act 1970. The Honorable Supreme Court held that the regulations were readily made and were enforceable since they were squarely covered by the powers bestowed on the Central Council of Indian Medicine by the Indian Medical Central Council Act 1970, now repealed by the NCI SM Act 2022. That with regard to the virus of Indian Medical Central Council Minimum Standard of the Education in Indian Medicines, Amendment Regulation 2018, the Honorable Supreme Court held as follows. As stated above, the point that arises for our consideration is whether the students seeking admissions to undergraduate courses, BMS, BOMS, BSMS, and BHMS, and postgraduate courses can be denied admission on the ground that they did not take the NEET or that they did not get the minimum percentile prescribed by 2018 regulations. It was contended on behalf of the institution that the students that the 2018 regulations are ultra vires the Act. No power is conferred on the Central Council to make regulation for introduction of an all India entrance examination under Section 36 of the Act. It is relevant to refer the provisions of Indian Medicine Central Council Act 1970. Section 22 of the Act confers power on the Central Council to prescribe minimum standards of education in Indian medicine, which are required for granting recognized medical qualification by the universities, boards, or medical institution in India. Section 36 provides that Central Council may, with the previous sanction of the central governments, make regulations generally to carry out the purposes of the Act. Section 36(1), we are in agreement with the contention made on behalf of the students and the institutions that the introduction of an all India examination will not be covered by Section 36(1)(j) and K of the Act. However, Section 36(p) refers to any matter under the Act for which the provisions may be made by the regulations. In our considered opinion, Section 22, which deals with the minimum standards of education in Indian medicines, cover the topic of an all India common entrance examination. We are supported in this view by a judgment of this court in Veterinary Council of India versus Indian Council of Agricultural Research. Section 22 of the Veterinary Council of India Act is in paramateria with Section 22 of the Indian Council of Medicine Act. An all India common entrance examination was introduced by the regulations made by the Veterinary Council of India in 1993, and an examination was conducted pursuant thereto from the academic year 1995-1996. The dispute pertaining to the validity of regulation was resolved by this court by holding that the Veterinary Council of India is authorized to frame regulations prescribing the standard of veterinary education, and such power includes power to make regulation relating to grant of admission and veterinary qualifications. This court observed that such authority to frame regulations regarding admission is necessary for maintaining the standards of the education. The instant case is squarely covered by the law laid down by this court in Veterinary Council of India Supra. Therefore, we are of the opinion that the 2018 regulations cannot be said to be ultra vires. Prescribing the minimum percentile, now this is important lawsuit. Prescribing a minimum percentile for admission to the undergraduate courses for the year 2019-22 was vehemently defended by the Central Council and the Union of India by submitting that the minimum standards cannot be lowered even for Ayush courses, including the BHMS and BMS also. We agree doctors who are qualified in Ayurvedic, Unani and homeopathic streams also treat patients, and the lack of minimum standards of the education would result in half-baked doctors being turned out of the professional colleges. Non-availability of the eligible candidates. Now this is a point which Lordship has raised. Non-availability of the eligible candidates for admission to Ayush undergraduate courses cannot be the reason to lower the standards prescribed by the Central Council for admission. And apparent from the above, the virus and authority of the impugned regulation has already been decided by the Honorable Supreme Court in Civil Appeal number 603/2020.
Where is this order?
Lord, I was showing.
Lordship, it has been incorporated in the my reply, Lordship. It is there in my reply.
Vikram Singh ji, WP number बताएंगे please. WP.
Milord, first your Lordship may see the 18 regulations. Milord.
WP number 9340/2022.
9340/22.
Yes, Lordship.
Page 31 in the petition is the 2018 regulations. which were subject of challenge before the Supreme Court. Page 31, Milord. These are called as.
No, this is Union of India versus Federation of Self.
Yes, Lord. Yes.
Ayurvedic.
Yes, Lord. I'm referring the same.
The P3, 56. You are reading this order.
I'm reading
Supreme
that
Court.
just gist of that order, Lordship,
All right.
which I have been incorporated there in my reply in that WP 9340/2020.
In all the cases I have filed the reply, I am appearing for the CCI, that is the clearing body. And this particular order, along with the division bench of the Delhi High Court, these two orders I have annexed as R1 and R2.
Milord, if I could complete my submissions, Milord, midway everybody has started, Milord. I was repeatedly saying, please see regulations 2018. My friend started reading something. I was showing 2018 regulations. I have said that Supreme Court decided it on 2 grounds. So I was not even, Milord.
They have derailed. They have derailed you.
No, I won't get derailed. But it's a waste of Lordship's time, Milord.
No,
Milord,
fine. Then let us first go through that judgment,
Milord,
and then when next time we sit, so we'll hear the remaining arguments, because there is the regular bench also which has to meet. Urgent matters are there. So when should we sit? You can fix a date or
Monday, Milord.
Monday.
Let them adopt the reply in other cases, Milord. Otherwise, they will have a grievance.
No, Monday. By Monday they will not be able to do that.
They have to adopt.
And also
They have a week in between. They just have to adopt via one
A
paragraph.
week is all holidays.
After holy vacation, Lordship,
Not
it
in
may
the
be
central
in the first
government.
state, Lordship.
Not in the central government.
Well, also even
We can adjust here and there.
I have to file the reply in relations.
Working for 4 days, 5 days.
I have to file the reply in relations to the homeopathic bunch of the cases, Lordship.
Week commencing 20th.
Milord,
Week commencing 20th March. Next week would be 13th, beginning from 13th.
some of their SLPs are listed on 13th also. Milord. They are alleging matters are not heard. Now here they are seeking time.
No, they should inform that the hearing has started.
What they inform is otherwise that we are avoiding.
But you are also there to correct them.
Now we will have to do that.
Let it be on 13th Monday.
Well, it's really clear that the matter council appearance the matter is partly heard. Full stop. Next paragraph. For hearing of the remaining arguments of learned counsel for the petitioner. List the case in the week commencing.
Milord, 14th or 15th kar de, Milord, I would be obliged. Milord.
All right, we'll place it on 14th then. All right, fine. आप लोग adopt कर लेंगे तब तक?
I will do it, Lordship. By that time, Lordship, I will file even reply in relations to that.
Let it also come that they are seeking.
Meanwhile, the who has to adopt?
I have to adapt the reply which has already been filed in Ayurveda cases, Lordship.
Not I. Who are you?
I am the government of India, Lordship. Union of India.
Union of India is directed to ensure filing of reply or adoption of the reply or
Yes,
filed
in respect of the bunch of the cases.
I am appearing for the CCIM, that is the parent body. In all the matters I have filed the reply, that is annexed.
All right. The commission.
Yes, my lord. The parent body, that is Central Council of Indian Medicine. Now it is National Council of Indian Medicine, my lord. Previously it was Central Council of Indian Medicine. In few of the matters, they have made me as a party. So I have filed the return.
And what about NEET? NEET that we have to ensure.
I will seek instruction, Lordship, on that.
All right.
Yes, Lordship.
Milord, Mr. Sanghi has also to file reply in 22-23 cases which are at the end of the list.
Lordship, copies of the petition for NEET may kindly be directed to be supplied in Lordship. Not for the NEET, Lordship, not.
All right. In which are those cases in which NEET is party? Please tell us those cases. इसमें लिखिए that after hearing part arguments, this court is of the considered view that it would be appropriate for proper adjudication of the issue to hear the National Eligibility
Testing Agency, NTA.
National Testing Agency, which conducts the NEET examination. Especially on the following aspects. Number one, the number of candidates who have secured the minimum percentile of 50%.
Percentile.
50% for unreserved.
Percentile, my lord.
Percentile. Yes. 50%. 50 percentile. Percentile of 50. You don't say 50%.
No, it is only 50 percentile marks.
50 percentile for unreserved and 40 and 45 also, I think. 40 for for reserved and 45 for handicapped in the last 3 years.
And those who have eventually taken admission in these alternate courses.
Number 2, the number of persons who have secured the aforesaid minimum marks have obtained admissions, have been given admissions.
In homeopathy or in Indian system of medicine,
And
both the faculties.
in different colleges imparting education in homeopathy as well as in Unani.
No, Indian system of medicine. That's
Indian
umbrella.
system
Yes.
of medicine
Indian system of medicine.
separately.
Your Lordship, the copies of these petitions wherein the need has been made the party, Lordship, may be directed to be supplied, Lordship. They have supplied the copy which I have already forwarded to the competent agency, Lordship. Lordship, I have to take instruction.
Can I, my lord, it is the state counseling, my lord, which will have this data. Because when we give admissions, we give the data to the state. The state has its own rules, my lord, for counseling, and they give the admissions, my lord. So probably, my lord, it is the state which will be able to give the position.
Counseling is held by
State, my lord.
state.
Yes, for obviously for state colleges in the state of MP.
So state has given that data or not in the reply?
Not given. Not given.
Huh?
My lord, NTA will give nationwide. If my lords are concerned about the Madhya Pradesh, then it is the state government which will give the colleges data of the state of MP colleges.
No, why should we ask?
Depends on what your lordship wants, my lord. वो national level पे क्यों बुला रहे हैं सर? वो that will be too much. अब वो केरला में क्या हो रहा है, my lord? That would not be very relevant. So let it be the state of MP. The government council may file the data with respect to. There are about 20 colleges, my lord. Not much. They'll have just a chart form, my lord. It's not a difficult thing.
All right. So next, let's see the state council should say it, is also directed to submit the following data. Number 1, what is that?
The number of students admitted, Lord, who had secured
The number of students who had secured the minimum percentile in NEET and were admitted to different colleges.
private colleges का ही
To the colleges who are party in these bunch of petitions.
गवर्नमेंट में तो जाएंगे ही नहीं, गवर्नमेंट में तो नीट से कम वालों को नहीं दे.
सभी का सिर्फ उनका. All the homeopathic and the Indian system of medicine colleges situated in running in the state of Madhya Pradesh. And then what else? Number 2.
How many? Lordship has said how many took admission. My lord, that is what.
How many seats were left vacant?
Which have been filled, my lord, through the interim orders of this court in last 2 years.
Last 2 academic years. And how many seats were left vacant in all the colleges in the state of Madhya Pradesh which were left vacant?
Which have been filled through interim orders of this court, my lord, in the last 2 years, my lord. In 21-22 and 22-23, my lord.
Number of seats filled up by way of the interim orders.
तो कोर्ट ऑर्डर्स के खिलाफ हो गया ना अपना. नहीं, कोर्ट ने परमिट किया है तो वी हैव डन इट. Now they say they don't recognize that. They don't recognize the court order.
They don't have that data. You have the data.
They have, my lord. After the last date of counselling, as per the court order, whatever admissions we have given along with all particulars.
So they are of persons who have not secured this percentile.
Yes, they are non-NEET. The order is that non-NEET because there is nobody coming forward.
Non-NEET means from where have you picked them up?
The 12th one above 50%, my lord, which is a qualifier. Yes. आज तक तो 40 साल से यही हो रहा है. 73 से 50 साल से.
No, but this was criticized heavily by Supreme Court in MBBS cases. Heavily.
MBBS के लिए जरूर है कि we don't want those kind of doctors. But different, my lord. एक होम्योपैथी की गोली खाना और एक That's correct.
नहीं वो नीट के लिए भी है. Sri Vikram Singh
Yes,
is
Lordship,
directed
I
to
was-
serve a copy, additional copy of the petition.
Yes, Lordship.
Since he is also been asked to appear for NEET.
Lordship, my presence may kindly be
Agency.
marked, Lordship. My presence may kindly be marked for all the respondents in Government of India, Lordship. In all the petitions, Lordship, because my name has not been reflecting. So even I've just brought the file
Name
right
of
now.
Sri Vikram Singh be reflected in the cause list.
Highly obliged, yes.
Henceforth for the Union of India and its functionaries.
Highly obliged, Lordship.
We'll just pass orders in the first case. That will be followed.